Ladies and gentlemen, shall we have our seats? A warm welcome to you once again. Welcome back from the master classes this morning. How many of us attended? Wow, clap for yourselves. So welcome back. This morning's master classes were in law and media, and the discussions thereof are expected to inform and probably did not attend yesterday. We started off with master classes in education, and we had panel discussions, 2 of them on ensuring privacy and data protection in mobile banking and digital payment platforms. And we also had a discussion on safeguarding privacy in Africa's IT landscape. And we had a chat on preserving privacy in investigative journalism, and as well as a chat on understanding the international finance corporations. So, ladies and gentlemen, in-house today, to continue with the discussions in the masterclass, we will be having 2 panel discussions in relation to the Convention on the Protection of Individuals with regard to automatic processing of personal data, and as well as a discussion with the regulators. We are so privileged to have the regulators in-house from some of our countries. I want to leave that at that and leave it for the segment. And we will also have a book launch, and as well as a presentation and the launch of the Unwanted Witness Privacy Scorecard Report. So in terms of highlights for the day, those are the things to expect. So ladies and gentlemen, to kick off our day, I wish to invite the Commissioner, the Data Protection Office of Mauritius, who will be moderating the next panel, and she will take it up from there. Ladies and gentlemen, Ms. Madam, the Commissioner.
Ladies and gentlemen, we are honored to introduce Mrs. Drudesia Madhab, a distinguished Data Protection Commissioner of Mauritius. With her profound expertise and dedication, she will be moderating the enlightenment on the Convention on the Protection of the Individuals with regard to automatic processing of personal data, TPD, by the Council of Europe. Ladies and gentlemen, Let us warmly welcome Mrs. Rhodesia Madhab to lead us through this remarkable session.
Very good morning to you all, ladies and gentlemen.
Hello.
Once again, a very warm welcome. We have been able to make it for the 3 days. You should be proud of yourselves, and all of us too. Thank you very much for your very valued and esteemed presence today as well. Namaste, salam alaikum, walaikum, bonjour, bonjour. Ce panel va être en français, puisqu'on est tous bilingues dans cette chambre aujourd'hui, donc il n'y aura pas de souci de traduction. Et j'espère que tout le monde va pouvoir suivre ce panel en français. Ce panel est dédié au Conseil de l'Europe et à la Convention 108 et la Convention 108+. Donc, de ce fait, c'est un panel que j'estime être peut-être un des plus importants dans le domaine de la protection des données, vu le travail immense que le Conseil de l'Europe a fait en termes de protection de données et de cybersécurité. Nous aurons parmi nous très bientôt le chef de département de la cybersécurité du Conseil de l'Europe, M. Patrick Pennings, et Mme Awa Nindae, qui est aussi de l'autorité sénégalaise, la présidente de l'autorité sénégalaise, qui va me joindre très bientôt. Donc, cette présentation, mesdames et messieurs, est axée sur la contribution de Maurice et des autres pays africains, aussi pour la promotion de la Convention 108+. Et laissez-moi aborder ce sujet. La Convention 108 internationale qui a réuni tous les principes importants et phares dans le domaine de la protection des données pour venir avec un instrument juridique contraignant au niveau international. Et je dirais que ce document, cet instrument juridique, représente une valeur inestimable dans notre domaine. Et pourquoi je parle de ça? Nous avons beaucoup d'autres instruments comme le GDPR, c'est-à-dire le RGPD de l'Union européenne. Nous avons aussi la Convention de Malabo de l'Union africaine. Nous avons d'autres documents régionaux au niveau du Asia-Pacifique. Nous avons aussi, en termes de documents dans les Amériques et les autres continents aussi, beaucoup d'instruments régionaux qui viennent ensemble pour joindre à cet effort de promouvoir une culture internationale de protection de données. Mais la Convention 108 représente quand même et toujours le seul instrument qui réunit, je dirais, en fait, le monde dans un contexte global. Et Maurice a ratifié cette convention en 2016 et a été le premier pays africain à le faire, en 2016. On est très fiers de ça parce que le premier pays africain, le message qu'on a voulu transmettre au continent et bien sûr à tous les pays, c'est que Maurice a eu cette intention de devenir un pionnier dans le domaine de la protection des données. Vu qu'on existe, notre institution elle-même existe depuis déjà 2007, qui fait un long parcours. Et j'ai pris cette initiative parce que une de mes fonctions très importantes, c'est aussi la coopération internationale. Et je donne beaucoup d'efforts, sinon beaucoup d'emphase, sur la coopération internationale, puisque la coopération internationale représente la survie de notre race en tant que privacy professionals dans ce domaine. La Convention 108+, c'est-à-dire le protocole modifiant la Convention pour la protection des personnes à l'égard du traitement automatisé des données à caractère personnel, la Convention 108+, on l'a ratifiée le 4 septembre 2020. Le premier pays non européen à le faire. Encore un signal très fort qu'on a voulu transmettre, pas que au continent africain, mais au monde, c'est-à-dire que Maurice a toujours cette intention d'être un pionnier dans ce domaine. Et donc, je considère que c'est une réalisation marquante pour la région. Second slide, please. Second slide, please. Next. OK, thank you. Notre loi sur la protection des données, le Data Protection Act de 2018, comme vous savez, cette législation, le Data Protection Act, a remplacé la législation de 2004 qui était venue en vigueur au février 2009 à Maurice, et le Data Protection Act de 2017 qui est entré en vigueur le 15 janvier 2018, en fait, représente un ensemble de règles qui est fortement inspiré de la Convention 108+. Même si la Convention 108+ n'est pas en vigueur actuellement au niveau international, mais le sera bientôt l'année prochaine, ce que je comprends bien, ou bien cette année-ci, je l'espère, mais on a voulu à Maurice, en fait, mettre tous les principes de la Convention 108+, les principes phares évidemment, dans notre législation, le Data Protection Act. Parce qu'on considère que l'implémentation de la Convention, dès qu'elle soit rentrée en vigueur, sera quand même un exercice qui demandera à chaque pays ratifiant la Convention un effort pour faire l'implémentation et l'incorporation, la domestication de la Convention dans le contexte local. Et on a ainsi fait cet exercice en 2018. On considère quand même que le Data Protection Act aussi, bien évidemment, comme vous le savez, est fortement inspiré du RGPD de l'Union européenne. Et dans ce contexte, ce serait bien aussi de vous faire savoir, je crois que vous êtes au courant, du projet de l'adéquation de Maurice avec l'Union européenne, c'est-à-dire d'être en conformité totale avec le RGPD. Ce sont des projets que le Bureau entame actuellement et nous espérons les concrétiser bien vite, sinon l'année prochaine. Notre loi sur la protection des données, étant fortement inspirée, comme je vous ai expliqué, de la Convention 108+, en fait rassure nos responsables de traitement, ce qu'on appelle les controllers, nos sous-traitants, c'est-à-dire nos processors, et les personnes concernées, les data subjects, que notre législation aborde les défis émergents de la vie privée sous le bon angle international, contribuant ainsi à construire une économie numérique sûre et digne de confiance pour Maurice. Next slide, please. Maurice donc voit un avenir prometteur pour la vie privée et la protection des données grâce à la Convention 108+, qui fournit le soutien parfait nécessaire pour concrétiser cette vision. La Convention 108+ vise un ensemble de normes élevées en matière de protection des données, tout en favorisant un environnement encore plus propice à l'innovation et à une croissance économique inclusive, en particulier dans les secteurs de la sous-traitance, des processus d'entreprise et des services financiers. Il s'agit du seul instrument multilatéral juridiquement contraignant sur la protection de la vie privée et des données personnelles, adapté aux nouvelles réalités d'un monde de plus en plus connecté. On parlait hier de Future of Privacy. La Convention 108+, est bien sûr un des éléments importants of the Future of Privacy. Donc, c'est un instrument légal et je vous conseillerais fortement d'aller le lire et de vous inspirer aussi, et les pays à le ratifier. Next slide. La ratification de la Convention 108+. Elle a permis un engagement envers la coopération internationale dans le domaine de la protection des données et de la vie privée. Cela a conduit à une collaboration accrue avec d'autres pays signataires de la Convention, au partage des meilleures pratiques et à la résolution collective des défis mondiaux de la protection des données. Next slide. De plus, elle a renforcé la confiance dans la protection des données et a eu un impact très positif sur l'environnement commercial à Maurice. Une confiance qui est vraiment importante et qui attire les investissements étrangers, favorise la croissance économique et renforce la réputation de Maurice en tant que lieu sûr et responsable pour le traitement et le stockage des données. Next slide, please. La Convention fournit un socle juridique pour la libre circulation des données à travers les frontières, ce qui est essentiel pour un pays comme Maurice qui dépend des transferts internationaux de données dans des secteurs tels que les services financiers et le commerce électronique. Les défis, on en a beaucoup. Next slide. Tout régulateur a cette aspiration de pouvoir, comme on dit en anglais, deliver the goods, including le contexte mauricien, bien sûr, moi aussi, et tous les régulateurs qui sont présents. Comme vous savez, dans le monde de la protection des données, les régulateurs sont parfois critiqués, parfois appréciés, parfois mal compris. Nous avons une mission qui est quand même très complexe et très délicate. L'équilibre entre le secteur public et le secteur privé et les exigences politiques aussi sont des considérations très importantes dans notre travail. Pour pouvoir vraiment diplomatiquement arriver à des buts ou bien des projets qui encouragent la participation de tout le monde et la coopération de tout le monde, c'est pas évident, c'est pas un travail qui est fait, je dirais, pour n'importe qui, malheureusement. Ça demande beaucoup d'implication, beaucoup d'investissement et beaucoup de tact. Parce qu'on attaque des domaines qui sont quand même, qui ont été des fois kept secret, comme on dit en anglais, confidentiels, des choses qui sont sensibles au pays, la sécurité nationale. Tous ces aspects qu'on traite, nous, dans le domaine de la protection des données, demandent quand même une personnalité et un professionnalisme assez élevé. Si on a des régulateurs qui sont, excusez-moi, je mélange l'anglais et le français, c'est normal, on est bilingue. Si nous avons des régulateurs qui n'ont pas cette énergie et le courage de pouvoir affronter ce contexte, on ne va jamais arriver à la mission globale qu'on essaye de faire. Donc les défis, comme je vous ai dit, on en a beaucoup. Le régulateur de la protection des données à Maurice et dans d'autres pays africains, et bien sûr l'autorité qui veille sur la protection de la vie privée. Mais si on n'a pas les ressources, le budget, l'expertise nécessaire, on va évidemment en souffrir. Et c'est le cas. On ne va pas le cacher, c'est le cas. On essaye de faire améliorer les choses dans la bonne direction et je suis convaincue, avec le support du Conseil de l'Europe, on va faire un gros pas en avant dans ce domaine. Donc, j'encourage tous les pays qui ne l'ont pas encore fait d'aller dans cette direction. Ce n'est pas ce qu'on dit en anglais data imperialism, c'est-à-dire la colonisation des données du continent africain. Ce n'est pas du tout ça. C'est en fait le respect profond des principes à cœur dans la vie privée. Et c'est ça la Convention 108+. Merci beaucoup. Et maintenant, je vais passer à Awa Ndai pour sa présentation. Et je serai on stage puisqu'on va modérer un panel. Et j'invite aussi Patrick à venir nous joindre. Patrick Pénix du Conseil de l'Europe. Et voilà.
Je me mets au milieu. D'abord.
Vous avez une présentation?
Oui.
Ouais.
Ah, j'y vais alors. Serre-moi. Merci. Bonjour, mesdames et messieurs. Je voudrais remercier les organisateurs du Symposium et remercier ma collègue et amie Drudesha. La remercier, comme d'habitude, pour l'accueil toujours agréable à Maurice, mais également la remercier pour son amitié et également pour ce qu'elle vient de dire en son nom personnel, mais au nom également de toutes les autorités de protection, particulièrement africaines. Je voudrais également, si vous me le permettez, remercier Patrick du Conseil de l'Europe qui m'a particulièrement invité ici aujourd'hui pour faire devant vous Elle a ratifié la Convention 108 depuis 2016. Et depuis 2016, nous avons noté, en tant que praticiens de la protection des données personnelles, nous avons noté un changement important avec la Convention 108, avec le travail que nous faisons au sein de la Convention, avec les échanges et le partenariat qui est le nôtre, avec le Conseil de l'Europe, le comité de la Convention et le bureau du TPD. Comme je le disais, l'histoire avec la Convention 108 commence en 2016, lorsque nous avons donc déposé les instruments et ratifié en décembre 2016 la Convention 108. L'adhésion du Sénégal à la Convention, nous l'avons tout de suite remarqué, a renforcé la confiance des acteurs du numérique. Bien entendu, avec la Convention 108, et c'était ça le véritable enjeu et le véritable objectif, c'était de disposer d'un niveau d'adéquation qui offrait davantage de garanties de protection à tous les acteurs de l'environnement numérique. Ce niveau d'adéquation que nous recherchions, propice à l'exploitation et à la circulation des données, rassurer donc les acteurs de l'écosystème au plan national, mais également au plan étranger, c'est-à-dire toutes les sociétés étrangères installées au Sénégal. Les entreprises européennes, par exemple, du service du numérique, qui dès 2007 ont commencé de plus en plus à s'installer à Dakar. Je ne veux que citer le nom de Atos, que tout le monde connaît, qui est quand même un géant du numérique, qui dès 2017, quelques mois après donc, notre adhésion à la Convention, s'est installé à Dakar en très grande pompe. Les banques étrangères également, qui sont nombreuses dans notre pays, ont commencé à décentraliser leurs services de back-office au Sénégal. c'est-à-dire que toutes les succursales dans la région, de la sous-région ouest africaine, les banques commençaient à décentraliser au Sénégal donc leurs services de back-office et faisaient de Dakar véritablement le local de toutes leurs activités de traitement de leurs données clients. Les centres d'appel sont importants parce qu'en réalité, si nous avons été engagés très fortement dans la ratification et l'adhésion à la 108, je dois dire qu'un centre d'appel nous avait beaucoup poussé, SAMRES, qui s'occupait justement de la délocalisation du service client de citoyens suédois à Dakar. Et donc, il nous poussait puisqu'ils étaient sur le point de fermer par défaut justement d'adéquation. Et lorsque nous avons adhéré, ils sont venus nous voir très heureux. Le directeur général a fait un déplacement sur Dakar. Et donc, là, nous avons vu à quel point il était important d'être à la 108 pour des aspects même économiques, hein, parce que tout le monde sait que les centres d'appel sont des organisations très pourvoyeuses d'emplois, particulièrement pour les jeunes. Quelque temps après, nous avons eu également Majorel, qui est un autre centre d'appel très connu, qui s'est installé à Dakar. C'est pour dire donc qu'il y a eu un déclic qui s'est fait avec l'adhésion du Sénégal à la 108. Mais en dehors de ça et parallèlement à cela, je voudrais quand même dire quelques mots sur les avantages de la 108, sur le travail même de l'autorité sénégalaise. Comme je l'ai dit tout à l'heure, il y a un avant et un après l'adhésion du Sénégal. Adhérer à la 108 et suivre de très près les travaux du bureau du comité, puisque nous avons eu la chance au Sénégal d'être membre du TPD et ensuite d'être un des vice-présidents du TPD. Donc, suivre ces travaux de très près, suivre les recommandations presque au quotidien, a donné à l'autorité sénégalaise une certaine envergure et également un plus grand sens de ses responsabilités au niveau national en matière de protection, mais également au niveau régional et africain. La 108 a renforcé en réalité notre statut dans la sous-région ouest africaine. Elle a renforcé au Sénégal également notre rôle de veille, de surveillance, de contrôle, mais elle nous a également positionnés comme un garant important d'une culture de protection de la vie privée. Cela, nous le devons à la 108, nous le devons à la Convention 108, qui est, comme l'a rappelé très justement Drudesha, le seul instrument international et juridiquement contraignant, qui est devenu en réalité pour l'autorité sénégalaise et pour plusieurs autorités africaines autour de nous, une référence. Une référence en matière de normes juridiques, une référence en matière de comportement à respecter dans le cadre de la protection des données des personnes, mais également de la protection de la dignité humaine. Donc une référence, mais un rempart également solide face aux innovations technologiques et aux nouveaux défis qui interpellent tous les jours les jeunes structures africaines en matière de protection des données. La structure qui est la CDP au Sénégal, donc la Commission de protection des données personnelles du Sénégal, je l'ai dit, je voudrais le répéter, a beaucoup profité de l'adhésion du Sénégal à la Convention. Notre cadre juridique a été véritablement renforcé. Ma collègue mauricienne l'a dit, c'est valable pour le Sénégal et je pense que c'est valable pour tous les pays qui ont adhéré à la Convention 108. La nomenclature juridique de la Convention a été un modèle, est un modèle pour les pays, les États parties, et donc nous a permis, nous, au Sénégal, de consolider les principes fondamentaux de protection des données, de renforcer les obligations des responsables de traitement et de consacrer des droits, et de nouveaux droits, aux personnes concernées. Nous avons pu profiter des travaux et des lignes directrices de la Convention pour mettre en place des garanties appropriées, définir de nouvelles garanties appropriées pour les flux transfrontières de données, par exemple les clauses contractuelles, etc. D'une certaine manière, d'une manière générale, nous avons beaucoup revu notre armature normative à la lumière de la Convention. C'est dans ce cadre que la CDP a développé des délibérations générales, des délibérations de portée générale, des recommandations et des jurisprudences qui tirent leur substance des lignes directrices et des recommandations du TPD. Je vais juste vous donner quelques exemples. Par exemple, la délibération de portée générale que nous avons élaborée sur la prospection politique au Sénégal, tout comme la jurisprudence sur le traitement des données de santé que nous avons élaborée, et le communiqué sur le traçage numérique et les recommandations donc, qui ont été faites pendant la période de la Covid-19, avec le rappel des règles de protection des données, nous ont permis véritablement de poser des jalons très forts en matière normative et en matière donc de réglementation. Et cela, nous l'avons fait en tirant véritablement les enseignements des travaux du comité de la 108. C'est donc grâce au soutien et à l'assistance du comité de la 108 que nous avons pu définir de nouvelles normes et que nous avons pu également interpréter plus finement les normes qui existaient et créer ainsi un espace sécurisé, économiquement ouvert, mais un espace également de confiance pour tous les acteurs du numérique. En matière de coopération, je dois dire que la Convention 108 a été également pour nous une occasion de nous ouvrir à d'autres structures, à d'autres zones géographiques, d'échanger et de créer des partenariats très utiles et très riches avec d'autres structures, avec des autorités de contrôle, mais également avec des organisations internationales qui sont parties à la Convention. Je ne voudrais ici que citer l'exemple avec les échanges que nous avons eus avec le Comité international de la Croix-Rouge, qui a été véritablement une ouverture pour nous et dans un champ d'application nouveau, qui est donc la protection des données dans le cadre de l'action humanitaire. La Croix-Rouge nous a véritablement poussé à investiguer dans ce cadre-là, à réfléchir par rapport donc à la protection des données dans le cadre de l'action humanitaire. Et ça a été la porte ouverte à une autre coopération avec le HCR et également avec Plan International, avec qui nous avons signé à Dakar des conventions véritablement très dynamiques et très riches qui se poursuivent encore aujourd'hui. Il y a eu bien entendu des échanges avec les autorités de contrôle, je l'ai dit. Je voudrais juste signer la dernière. Nous avons reçu à Dakar le Bureau fédéral de la protection des données personnelles et de la liberté d'information de l'Allemagne, avec qui nous avons tenu une séance de travail très riche. Mais je dois dire que la Convention 108 et le travail de la Convention a été au centre de nos échanges et a permis de renforcer notre volonté de mettre en œuvre un partenariat dynamique entre nos deux structures. Un autre moment très important et qui nous a beaucoup enrichis, c'est cette série d'ateliers, de sessions de renforcement des capacités qui avaient été initiées par le Conseil de l'Europe, destinés aux autorités africaines de protection. Ce sont des ateliers sur des thématiques importantes, comme le droit à la protection des données, l'identité numérique, les fintechs. Donc, nous avons là vécu des moments intenses d'échanges entre autorités, mais entre autorités et membres du Conseil de l'Europe, membres du comité de la Convention, échanges qui ont véritablement mis à jour ce besoin de se parler, ce besoin d'échanger donc nos bonnes pratiques, besoin d'échanger les préoccupations qui sont les nôtres, et véritablement, nous regrettons juste que ça n'ait pas perduré. Et c'est un des défis que je voudrais souligner. Renforcer la coopération entre les États parties à la Convention 108 me semble être un défi majeur que je souhaiterais véritablement que nous adressions. Parce que le travail du TPD est un travail immense. Je suis bien placée pour le dire, puisque depuis maintenant 2018, je suis membre du TPD, donc du bureau de la Convention 108, et le travail que nous faisons dans plusieurs domaines est un travail extraordinaire d'enrichissement, de réflexion, d'innovation. Ce travail, il mérite d'être vulgarisé, il mérite d'être mis à la disposition de tous les États qui sont partis à cette convention. Et il faudrait voir comment faire en sorte de mieux renforcer la coopération entre les États pour pouvoir justement apporter tout ce travail et cette réflexion à la portée des différents membres. Moi-même, je vis ce besoin, puisque avec mes collègues de la Mauritanie, du Mali, du Niger, du Maroc, très souvent, j'échange, je partage les documents du TPD pour justement leur permettre de mieux mettre à profit les enseignements et la nomenclature et l'armature juridique du TPD dans leur travail quotidien. Pérenniser peut-être le renforcement des capacités des autorités de contrôle par des ateliers qui vont nous permettre de vulgariser cet immense travail et d'échanger autour de ce travail devra être certainement un axe à visiter. Je voudrais également, toujours en matière de proposition d'axes de travail, dire ici, puisque j'ai peut-être la chance d'être beaucoup en contact avec les autorités africaines, dire le besoin de se pencher sur la protection des données personnelles dans le cadre de la lutte contre l'immigration irrégulière. C'est un fléau, c'est un problème qui nous interpelle en Afrique, mais qui interpelle également l'Europe. Et donc, je pense que mettre en place, élaborer des lignes directrices qui encadreraient le traitement pour l'identification des migrants irréguliers, je pense que c'est un travail qui devrait être fait, qui doit être fait. Et c'est un travail sensible, c'est une matière difficile, délicate, mais c'est justement cela que nous attendons de notre collaboration et de notre partenariat avec la Convention, le comité de la Convention 108, c'est d'adresser justement ce genre de sujets et de thèmes qui sont nos préoccupations et véritablement de voir comment mieux donc réfléchir sur sauvegarder la dignité des migrants, même s'ils sont irréguliers, sauvegarder leurs données personnelles, tout en, bien sûr, traitant donc ces données, tout en faisant face à ce problème et à cette problématique et en essayant de la résoudre au mieux. Donc, peut-être créer un cadre de partenariat avec le réseau des autorités africaines qui est véritablement interpellé chaque jour dans ce domaine. Donc, cadre de partenariat entre le comité de la Convention et le réseau des autorités africaines favoriserait l'échange et la réflexion sur des thématiques communes. Je voudrais, pour finir, pour ne pas prendre trop de temps, recommander une dernière chose. Et c'est une recommandation urgente pour moi, qui est un besoin, une recommandation que je voudrais ici partager avec vous. J'en discutais avec ma collègue de l'Ouganda. Beaucoup de pays africains aujourd'hui, je parle pour eux parce que c'est eux que je connais le mieux, si je puis dire, souhaitent être partie prenante à la Convention 108. Mais un problème persiste et subsiste, que nous vivons nous-mêmes à Dakar, au Sénégal, c'est faciliter l'adhésion à la Convention 108 et à la Convention 108 plus aujourd'hui. Comment faire pour aider les pays à adhérer plus facilement à la Convention 108 plus? Nous y avons beaucoup réfléchi, je dois dire, avec le comité du TPD et avec Isabelle, qui préside le comité de la Convention 108, à faire un effort pour renforcer le plaidoyer donc à l'international pour que les adhésions des différents pays qui ont envie aujourd'hui d'être partis à la Convention soient véritablement facilitées. C'est un besoin qui doit être pris en charge. Et c'est, je pense, à mon avis, ça doit être un aspect du travail du secrétariat. Je le dis devant Patrick, puisque lui-même a donné donc son accord pour pouvoir entamer une discussion avec les autorités nationales sénégalaises. Et je pense qu'il faudrait peut-être réfléchir à formaliser quelque chose de léger, bien entendu. Il ne s'agit pas d'y mettre beaucoup de fonds, mais quelque chose de léger qui permette que le secrétariat puisse faire déplacer une personne pour soutenir le plaidoyer que nous, autorités de protection des données, dans nos pays respectifs, nous menons pour faire adhérer nos pays à la Convention 108, mais soutenir ce processus, soutenir ce plaidoyer doit être un engagement fort et une des missions également importantes du secrétariat du comité de la Convention. L'engouement pour être parti à la Convention 108 est un engouement justifié. La Convention, nous l'avons dit, c'est véritablement le garant de la vie privée, le garant de la protection des données au niveau mondial. La Convention 108 est également une force de proposition et également de conseil et d'assistance pour les autorités de protection. Il doit être ouvert à toutes les zones géographiques. Il doit être présent partout où il se doit. Et il doit véritablement être physiquement un instrument international, un instrument mondial, c'est-à-dire représenté, il doit être ratifié par tous les pays dans le monde pour que justement cette économie numérique que nous souhaitons puisse véritablement être vivifiante et vivifiée par les différentes parties. C'est donc sur cela que je voudrais finir en demandant que soit renforcé donc le plaidoyer pour permettre un maximum d'adhésion à la Convention 108 parce que la Convention 108, elle est véritablement un instrument, pas seulement juridiquement contraignant, mais un instrument de travail pour toutes les autorités de protection. C'est véritablement notre bréviaire, il est véritablement le rempart à de nombreuses dérives aujourd'hui auxquelles nous assistons dans le domaine du numérique. Je vous remercie.
Parfait, merci beaucoup.
Merci beaucoup, Awa, pour cette présentation qui est très enrichissante et très informative. Et je passerai maintenant à Patrick Pennings, représentant du Conseil de l'Europe. Et Patrick, vous voulez vous introduire plus longuement que moi?
Je peux le faire, mais j'ai d'abord une question. How many of you would like me to speak in English? Parce que je sais que les Mauriciens parlent parfaitement plusieurs langues, mais peut-être les invités internationaux, the international guests may want. Is it okay if I speak English?
Yes, I think so.
Can I give a sign?
Yes. Okay. So what we will do exactly is I'm very grateful to Patrick to suggest this. We will do a hybrid session, both in English and in French. Awa va parler en français, je parlerai en français, and Patrick will speak in English. Okay. To be fair to each and every one of us. Mm-hmm. So, Patrick, the Convention 108 exists since 1981, And it's actually at the root of the celebration of the Data Privacy Day internationally every year.
That's right.
The world celebrates the Data Privacy Day in commemoration of the Convention 108, which I think deserves the great gratitude to the Council of Europe for the work done behind enacting the Convention 108. So could you please tell us more about the initiatives of the Council of Europe, the history dating back to Convention 108, and what it is today to you in terms of Convention 108 plus? Thank you, Patrick.
Thank you. Thank you. A pleasure and a privilege to be here. I would like to thank, of course, the Data Protection Authority of Mauritius, but also Unwanted Witness, who has been instrumental in organizing this. In fact, Rudesha, I will only have very short 4 messages and 2 invitations. So stay for the invitations if you don't want to listen to the messages. First of all, I'm covering within the Council of Europe different areas of activity. The Council, as you know, stands for a number of rights. It stands for democracy, the rule of law, and human rights. And the work that we do within the Council of Europe, whether that be on data protection or cybercrime, fits within that context, and that's important. My job in the Council is to deal with rather innovative areas of work which stand right now at the center of development. Obviously, data protection has been part of it for over 40 years, not for me personally, but for the Council of Europe, cybercrime, and we're also moving into the area of artificial intelligence. So those areas have to be looked at together. On top of it, and my colleague yesterday spoke about investigative journalism and data protection, the media sector, freedom of expression is also part of my remit, as well as the cooperation with business partners. All of that fits in neatly together, because obviously if we speak today in fact, we have to keep abreast of those developments. And that's also why when my colleagues here speak about Convention 108 and Convention 108 plus, I have to clarify it a little bit. First of all, conventions, the Council of Europe is not a European Union. We're speaking about a conglomerate, an intergovernmental cooperation between right now 46 states in Europe. But many of our instruments are open instruments. They are open. That basically means not only in their application we do invite states outside Europe, but also in the case of the development of the conventions, those countries outside Europe are invited to participate in their elaboration. And that's an enormous difference when you look at it at a global level. Why? We are past the stage of a Eurocentric development of standards. We need to be able to develop those standards in that global context. And that basically means, and both Awa and Rudesha have mentioned how the Convention 108 and Convention 108 plus allows the joining of such a convention allows you to respond to the adequacy principles, which are, and that's what Rudesha also mentioned, that we are working on, and what the countries themselves have to be working on the adequacy principles to cooperate with a body such as the European Commission at the European Union level, where they can see that the accession to Convention 108 and Convention 108 Plus are elements in such an adequacy decision. So that's important, an open convention where the reflections of all those that are party to it are incorporated in the global reflections. For example, right now, there's a whole debate about data protection and national security. These are issues which do not concern one particular country, but they concern all of us. We need to be able, from a data protection authority side, we have to be able to lay down a number of principles that we see as guiding principles for all. Same comes for example, video surveillance, mass surveillance, biometric recognition. These are issues that we need to look into together. Even if we're not there yet in our own countries, these are the issues that are coming up and that we need to be able to start looking into. That's why within the Council of Europe, bringing those areas together of data protection, cybercrime, artificial intelligence, and new developments within artificial intelligence. For example, we started to look into immersive technologies and the impact of immersive technologies on data gathering. Because we're talking here not only about sensitive data, but about very intimate data. Because in order to be able to take part in those immersive realities, we will have to beef up the number of biometric data, for example, but physical data that we will be providing again to such a setting which is primarily composed of private industry. When we were setting up the data protection over 40 years, the Data Protection Convention over 40 years ago, which officially is entitled the Automated Processing of Individual Data. I can't imagine, 41 years ago, that must have been extremely forward-looking. Because at the time, I'm sorry to say, but our administrations were keeping paper files on citizens. But already there, it was important, before the age of computers, to be able to say, we have to be careful about where this development may go. And at the time, it was primarily focused on governments collecting data. We're in a completely different setting. Governments do collect data, but Rudesha, if I may say, if I'm filling out a health form and a, let's say, a migration form when I land in Port Louis, my question is always, to which extent will this be handled and how will it be handled, you know? But our private sector is moving much further ahead. So that's the first message. We're talking about open conventions where every state that wants to be an observer to it or wants to be a participant to it, such as those two ladies here next to me, representing their countries, it's important that this is possible and that is to see. And both of you already also mentioned my second point, is right now the only international binding legal instrument. That basically means we are putting up a benchmark that we say, listen, you guys, when we are part of it, this is what we are signing up to. And we sign up to it not only internally in our own country, it's not a piece of legislation that we want to adopt in order to comply with something. We want to implement it, and we want to be seen to be implementing it, which in international context, obviously, is crucially important. Third element is the continuous development of technology and our need to adapt. That's why the link to other conventions which are based on those same principles. Mm-hmm. How do we protect human rights? How do we protect the rule of law? How do we protect democratic societies? And with these conventions, how are we going to do that in a technologically advanced world where we need to constantly, together again, reflect on what we are doing. The fourth element is we need to address those issues not only at an ethical perspective, from an ethical perspective. We need to make it hard legal, give it a hard legal basis. And third, we also need to ensure that it operates. Drudesha on the first day gave us a wonderful example of her own establishment of the Data Protection Authority here in Mauritius and the battle that it provokes. And I'm sure that in Senegal it has not been any different. Mm-hmm. It is a fight to be able to ensure that this is recognized. And I can tell you sometimes when I then ask about such things in a hotel, for example, of how do you comply with those standards, there's always, even though they know that they exist and that they will need to comply with it, there's always a little bit of, yeah, well, we'll see how we'll do that. That's why the authorities are there in order to be able to implement it. Mm-hmm. Now, I have two invitations, as I said. The first invitation, and both of you have referred to it, the first invitation is you can be part of it. There is a system, and right now we're up to around 40 countries that are actually following the debates within the so-called TPD, which is the treaty body dealing with data authorities. In some countries, these are mixed delegations of the state officials and of the independent authorities. So that's important that to deposit the instrument with our Secretary General. So there are simple procedures for this in order to be able for you to become part of it and be able to give your voice into the discussions that are taking place. Because if we discuss national security, it's not only for European countries. And by the way, a number of European countries that I'm talking about, of the 46, are in certain respects far less developed than some of those authorities here, and that I've been listening to over the past couple of days on what your efforts are in the different countries that you present. So, part of it. You can become an observer to it. And that's, we can discuss details about it later on. Second invitation, and that was maybe more inspired by the videos, which are excellent. Thank you so much, because they give us a very lively picture. Well, we are opening now an annual competition, which is the Stéphane Rodota Prize. Yes. And the Stéphane Rodota Prize is actually for a research that is being done on data compliance, data protection related issues, and that's open to international entrants. So I would invite you, if research is ongoing, please make sure that have a look at the Council of Europe website on the Stéphane Rodota Prize, and we would invite you to send in your own applications. And the other thing, actually, which was not on my list, is the moot court competition that I saw. That creates, because, you know, it's not about training young lawyers. It's also about embedding the rule of law in our societies. The fact that we can state and that we are educating those young people to the predominance of the law. And at the European level, there is a moot court called, for the French-speaking community, the René Cassin Prize. And the René Cassin Prize is also actually a moot court competition devoted not solely to data protection, but to human rights in general. So with those 4 messages and those 2 invitations, I would like to continue with the panel now. Thank you.
Thank you so much, Patrick. This has been really enriching because I believe this will be helping the Council of Europe in promoting it through our local universities as well. Mm-hmm. That's something that I said to myself, oh, I forgot, we have to do this. And we are going to definitely do that. And I think, Patrick, I will just be staying with you a little bit more. Mm-hmm. You know, these challenges, these, you know, digitalization challenges, everything that is happening so fast in technology, everyone is very proud of technological advancement and development. But at the same time, people always overlook the other aspects because, as I said the other day, the marvels of technology actually blind our eyes because we're so fascinated and attracted to the technological world. But definitely, I think the challenges for us, regulators, you know, all the international institutions, how do you see, you know, the value, our contribution even more in this very fast world? The challenges are actually what I wanted to ask you from your side and your own experience internationally. Thank you, if you could respond to that.
Yes, of course. Technology moves fast. Some say move fast and break things. Others say, well, it's good, and we'll probably, there are so many advantages as new technology can bring. And let's ensure that we do not stifle innovation. That's a starting point. I think stifling innovation would be like breaking the weaving instruments at the beginning of the 19th century, or at the end of the 19th century. We have to incorporate innovation. We do not know what tomorrow will bring with all the developments, and we've heard it with the Internet of Bodies and the interconnectivity of things. We spoke more about in the past the Internet of Things, the development of 5G, the development of what was called only 2 years ago the GPT-3, and it became a hype when it was called ChatGPT. Generative artificial intelligence, linguistic models, we will not be able to anticipate it all. That would be a false presumption, and very presumptuous actually. But the idea is that we need to be able, without strictly defining, but more in a technological neutral way, how do we stand with regards to those developments? What do we want to preserve within human society to keep a human-centered approach to the development of artificial intelligence with a societal model that we want to preserve? Because let's face it, technology is not neutral. And we've spoken in the past a lot about privacy by design, human rights by design. That is, to which extent do we reflect on how that technology is going to impact the basic values that we want to preserve in our society. Now, what you want to preserve in your society is that is for the community, for the state, for the government to decide, for the people to decide. And we see also in Africa and in Europe and in Asia quite a number of authoritarian tendencies, let's face it. The number of liberal democracies in the world is going down. It's, I think, about only 1/3 of our country, of the world's population, lives in a in an elective democracy, not even a liberal democracy. So it's a question of what do you want to pursue. And if you want to pursue a democratic society with respect of those rule of law and human rights, at that point in time, we also need to put some benchmarks. And those benchmarks, and that's why the work that we are doing right now on the development of a new convention on artificial intelligence, in which not only the European countries are involved, but also the United States, Canada, Japan, Israel, a number of countries are involved, including also Argentina, Uruguay, who have recently signed up for it. And that's maybe my next invitation. That is, be aware of that this is happening. You're invited to become an observer to that. It is a simple procedure for a country to ask to be part of that development. And not to be left out from the start. And then you can decide and even if at your own country level, you do not necessarily, because we're all grappling with it, let's face it. I went to the Dutch Parliament before the summer and to the Belgian Parliament. And they said, well, with what you're telling us, do you want us to go ahead with legislation or do you want us to wait for legislation? There's no one single answer. If in your society the developments are such that you are ripe to be able to set a number of standards, make those standards. But what we try to do, and that's why also Convention 108 and Convention 108 Plus are so important, is that don't get it wrong.
Yes.
Let's make sure not to get it wrong. And if you have a community with, for example, data protection authorities that have different perspectives and can bring those perspectives together in order to say, well, having well reflected about this, this is how Cybercrime Convention, again, define things technologically neutral in order to be able to respond to new developments. I took out my mobile phone, I left it in my bag, but and ratified in 20 years ago, mobile phones didn't exist. So we had to define, is a mobile phone, and let's face it, every one of you has at least one of them in your pockets, generating data for big tech to identify you even better. We needed to decide, is a mobile phone, is that a computer system? Yeah? If I would now ask here anyone, of course, everyone would say, yes, it is a computer system. It's probably, I don't know how many hundreds or 1,000 times more powerful than the first computers I was learning to work on at university. Yeah? So we have to make it possible to evolve, not to get ourselves in a straitjacket, but ensure that the lines of thought and development that we're having are sufficiently general, probably, sufficiently open in order to tackle that. And no one has the answer.
The right answer.
No one has the only answer. If you look at the summit a week ago in London about artificial intelligence, obviously there's many different points of view.
Yes.
Some say slow down, others speed up.
Yes. Yes,
So-
Patrick, I'm very happy to have you, that you have shared so much of information with us. And I would just like to say that Mauritius is proud to have signed the Budapest Convention for Cybercrime, has even enacted a Cybercrime Act in Mauritius quite recently, and all the Data Protection Act is already here. Now we're coming for the Convention on Artificial Intelligence, as you recommended. Awa, would you like, en français, alors, est-ce que tu voudrais nous dire un dernier mot après ta présentation sur ton travail comme vice-présidente du TPD, excuse-moi, et aussi comme membre du réseau africain des autorités de la protection des données personnelles, qui fête ses 10 ans, si je comprends bien. Awa?
Alors, oui, le Sénégal fête ses 10 ans.
Voilà.
Fête ses 10 ans, donc dans son travail de protection des données personnelles. Nous fêtons cette année nos 10 ans d'activité. Mais comme je l'ai dit tout à l'heure, nous avons une coopération très active, une coopération régionale, africaine et internationale très active, que nous avons voulu très active, parce que nous avons le sentiment que rien ne peut se faire dans ce cadre de protection des données, comme tu l'as dit tout à l'heure, en se refermant sur soi-même. On a le besoin et le devoir de s'ouvrir aux autres. Et s'ouvrir aux autres, c'était vraiment une chance et une opportunité extraordinaire d'avoir un pied dans la Convention, dans le comité de la Convention, et de pouvoir faire partie des acteurs presque au quotidien du travail du comité de la Convention 108. C'est vraiment une opportunité extraordinaire, et je voudrais, puisque mon mandat va bientôt se terminer à la tête de la commission de protection sénégalaise, et j'ai émis l'idée avec Isabelle que véritablement l'Afrique soit encore représentée au niveau de ce travail, au niveau de ce comité. Ça me semble extrêmement important, parce que le travail du comité de la Convention est un travail qu'on ne peut même pas imaginer lorsqu'on n'est pas dedans.
Je suis d'accord avec toi.
C'est un travail extraordinaire, où l'on aborde tous les thèmes,
Tout à fait.
tous les défis, toutes les problématiques, en réalité, sont abordées, réfléchies, discutées, hein, et nous avons toujours la possibilité d'avoir des experts qui nous donnent un point de vue globalisant, et véritablement, les expériences des uns et des autres venant de différentes aires géographiques, de différents pays, de différentes sensibilités, sont extrêmement enrichissantes et fructueuses. Donc, c'est vraiment un travail extraordinaire, et franchement, moi, je t'invite à faire partie de ce comité, de ce travail, et ce travail
toute communauté africaine, et je viendrai avec ce point très fortement pour dire que effectivement, le travail que le Conseil de l'Europe fait actuellement et a fait dans le passé et fera dans l'avenir est vraiment merveilleux. Je suis partie de cette équipe et je peux vous dire et vous confirmer que nous abordons vraiment tous les sujets en ce qui concerne la technologie et la protection des données et la cybersécurité. Merci beaucoup. Ça a été un plaisir de vous avoir parmi nous. Et Awa, vous restez toujours sur scène.
Merci.
Merci beaucoup. Merci Patrick.
Merci à toi. Merci. Et à bon entendant.
Merci.
Je reste?
Oui, vous restez.
D'accord.
Gentlemen, can we give a round of applause to our panelists and the good job done by Madam Commissioner?
Thank you.
So, we've not done a Q&A, but we can take it in the next, as part of the next segment. We will have the next panel that will be comprising of the regulators that are in the House. I will leave the announcing of who and who is in the House to the moderator. So, ladies and gentlemen, let's put our hands together to welcome our next moderator, and as well as who will in turn introduce the panel members. Thank you.
Ladies and gentlemen, we are honored to introduce Igstel M.A. Dopgima, a distinguished New York barrister at law and a proud member of the Cameroon Bar Association. Her expertise and dedication have made her a new prominent figure in the field of data protection. Join us for an enlightenment session, conversation with Africa Data Protection Regulators, hosted by Igstel M.A. Dopgima. Her insights promise to illuminate the path of forward in its vital domain. Ladies and gentlemen, welcome Igstel M.A. Dopgima.
Supervisory authority whose purpose is to ensure compliance with the respective data protection laws. Popularly called data protection regulators, they have borne the Herculean task of pioneering the advocacy and compliance efforts in their various countries. We are honored and we are privileged to have present with us today the data protection officers from Mauritius, our host country, Uganda, Senegal, Ghana, and the head of OECD's Data Governance and Privacy Unit. The objective of this session is to provide a platform for the African data protection regulators to share their experiences, insights, and best practices in fostering data protection regulations. This session aims to identify common challenges faced by African countries, highlight successful strategies for overcoming these challenges, and explore the potential benefits of collaborative compliance efforts. At this juncture, I will introduce you to the data regulators who will join me here on stage. Some are already here, and a few that we have online. In recognition of their work and office, put your hands together for Ms. Clarice Giroux, who is joining us online. Please, shall you? Clarice lived in Singapore, where she held the first position as senior fellow at the Asian Business Law Institute. She launched and led a flagship project on the convergence of data protection laws and flow regulations in 14 jurisdictions. Welcome, Clarice. In recognition of the work and office, put your hands together for the Honorable Patricia Adose Poku, joining us online. Ms. Patricia is the Executive Director of the Ghana Data Protection Commission. She's a seasoned privacy practitioner, program manager, information governance and risk expert in public, private, and non-profit sectors globally. Some of her recent appointments include she being appointed as the head of data protection at the London 2012 Olympic Games. She is currently the co-chair of the Common Thread Network of Commonwealth of Data Protection Authorities, and she is the president of the Network of African Data Protection Authorities. Welcome, Ms. Aduse Poku. In recognition of the work and office, kindly put your hands together for the Honorable Awa Diaye. Ms. Awa Diaye is the president of the Commission for the Protection of Personal Data. She's a holder of a doctorate degree in French literature and a high diploma of diplomatic studies. She has several times been Minister of State and technical advisor to national, regional, and international institutions. She is a lecturer at the Department of Modern Arts at the University of Cheikh Anta Diop in Dakar. Welcome, Ms. Diaye. In recognition of the work and office, please generously put your hands together for the Honorable Stella Alibatis. She's here with us and she'll be joining us on stage. Protection Office is an independent office set up under the National Information Technology Authority in Uganda that is responsible for the personal data protection in Uganda. She is responsible with 10 of those years being in the ICT sector. Welcome, Ms. Alibatis. And last, definitely not the least, in recognition of the work and the office, please put your hands together for the Honorable Judicia Madop. Ms. Judicia Madop was appointed Data Protection Commissioner for the Data Protection Office of Mauritius since August of 2007. Prior to her appointment, she was the Senior State Counsel at the Attorney General's Office for 6 years. She is a respected member of various international networks, such as Association Francophone des Autorités de Protection de Données Personnelles, Réseau Africain des Autorités de Protection de Données Personnelles, forgive my French, Global Privacy Enforcement Network, Common Thread Network, the Council of Europe, and the United Nations Global Pulse. Ms. Madop was appointed UN Emeritus Expert, joining the UN Global Pulse Data Advisory Group in 2014 to provide expert advice on data protection. Ladies and gentlemen, I hope you recognize the unique opportunity you have here before you as professionals with an interest in the domain of data protection and privacy. We will have a segment for you to directly ask questions to the regulators, so prepare your questions in time as we go into their trajectory to learn about their successes, their challenges, and the work in their respective jurisdictions. Thank you. All right, Ms. Madop, we're going to start with you.
Thank you.
You have the honor of answering the first question that we have.
Thank you, Excel.
Africa standards, and what support mechanisms can they put in place to assist them?
Definitely, I think right now this is the biggest challenge for the African continent, is how African brothers and sisters and countries can help each other in making sure that where privacy is heavily important and prioritized, that we actually bring privacy to our homes. And definitely, to start with, I would say, should we not have the will and the commitment of the government, nothing moves. You know, it's the responsibility of a state to ensure that its people are protected in the right way. And that is national sovereignty. And there's nothing that's, even an international organization or us, collaborators in the region can do without the support of a government, of a state. And I have seen in Africa the problem with not only the African continent, but the problem with anywhere in the world is that if we do not have an educated government, if we do not have, educated, by education I mean not literate, I mean educated in the field that we are, privacy. Definitely privacy is never going to be a priority for our governments. I said it the other day, where in countries in Africa, like you said, less developed countries in Africa are facing huge problems right now in every aspect of life. And should we give priority to other issues, which is more important than privacy? Let's acknowledge it. We should. We should. But privacy is also a long-term investment, isn't it? You heard the Council of Europe representatives saying, we started 41 years ago. There were not even mobile phones at the time, but we started. That is, we were being process. That's why privacy, data protection laws call in a lot of proactivity. We talk about this as one of our privacy by design. That is, you do it at the start. We're never at the ending process. We're always starting things from the start. And this is one of the most important fundamentals in data protection, being proactive. So should we be proactive? We should be lessening our miseries and our worries for the world that is going to be in the near future.
Thank you very much. That's insightful and prompts me to ask Honorable Awa the question for Senegal. How, in any way, has your office prompted the government of Senegal to pay more attention to the importance of the protection of personal data of its citizens? If you can share any initiatives done by your office, that will go a long way.
Je vais répondre en français, si vous le voulez bien.
It's fine, yes.
À une question très difficile. Une question très difficile parce que, en réalité, elle est au centre de nos difficultés. Drodechia vient de le dire. La question de la protection des données et de la vie privée est une question qui doit être prise en charge par les États. Il doit y avoir une volonté des États d'aller de l'avant dans ce domaine, étant entendu qu'on ne peut pas ne pas faire avec tout le monde. On ne peut pas faire autrement. On est obligé de rentrer dans ce train-là si l'on ne veut pas rester en gare pour toujours. Donc les États doivent être conscients de cette obligation de rentrer dans le train du numérique. Et rentrer dans le train du numérique, qui sous-entend une économie avisée, forte, ouverte, avec des échanges rapides, mais qui sous-entend également sécuriser, des échanges sécurisés, la confiance entre les investisseurs, la confiance entre les acteurs qui sont donc au centre de ces échanges, c'est-à-dire les populations. Tout cela sous-entend que les États eux-mêmes soient conscients de leurs responsabilités et de leur obligation de consolider et de fortifier les autorités de régulation de ces données qu'ils ont mis en charge. Le problème et le paradoxe, je ne sais pas en Europe, mais le paradoxe en Afrique, c'est que nos États, autant mettent en place des structures, autant ne s'occupent pas de ces structures. C'est comme si ces structures étaient mises en place uniquement pour faire genre. Pour faire genre, je suis conscient qu'il y a quelque chose qui se passe dans le monde et je suis dedans. Mais en réalité, ce n'est pas leur problème, si je puis m'exprimer ainsi. Ce n'est pas leur problème parce qu'aucun moyen réel n'est donné et n'est accordé aux régulateurs pour pouvoir faire leur travail. Je prends ici l'exemple de la Convention de Malabo. Cette Convention de Malabo, qui n'est pas encore aujourd'hui entrée en vigueur, qui va l'être très bientôt, mais qui a été déjà élaborée depuis 2014 et qui va peut-être cette année ou l'année prochaine entrer en vigueur. Voyez le laps de temps, le temps qu'il a fallu pour faire signer les différents États. Cela est déjà symbolique de ce manque de volonté de nos États et de ce manque d'adhésion qu'ils ont à des choses qui sont extrêmement importantes. Aujourd'hui, en Afrique, on parle de la ZLECA. On parle du commerce régional, du commerce donc continental, et on parle de comment faire en sorte que ce commerce, ce e-commerce entre les États, soit riche, soit vivifiant, soit fructueux. Comment le faire sans protéger, sans sécuriser les investissements et les investisseurs? Comment le faire sans sécuriser les données personnelles qui vont être utilisées, traitées, malaxées par les uns et par les autres? Comment faire sans réguler ce flux de transfert de données d'un pays à l'autre? Comment faire pour que cette souveraineté des données soit véritablement quelque chose qui existe et une réalité en Afrique? Où héberger les données? Le problème de l'hébergement des données, le problème des data centers, tous ces problèmes doivent être mis sur la table et pris en charge par les États. Malheureusement, c'est rarement le cas, de sorte que nous poussons autant que nous pouvons en tant que régulateurs, mais notre voix ne pousse pas très loin, malheureusement.
Because this is such an important subject, this is something that we as privacy professionals think about for the most part. We're going to dwell a bit on this question so we can hear from the experts, from their different jurisdictions, ways in which, if possible, we can nudge our governments to pay closer attention to the protection of personal data. So to you, Ms. Stella, what have you witnessed in Uganda, maybe, that has prompted the government to pay closer attention to the importance of the protection of data privacy and protection of their citizens that you can share with the audience, and ways in which maybe Africa can come together so other heads of states and governments can pay closer attention to this issue?
Thank you, Ixtel. Good afternoon, everyone. Thank you to Unwanted Witness for the Privacy Symposium Africa. I'm happy to be here in Mauritius and to see Mrs. Madoub. We've been interacting mainly online since COVID, so I'm really happy to be here. Of course, we cannot overemphasize the need for regional frameworks in nudging our governments to protect or to put in place laws that protect personal data. For the East African case, we do have the EAC Cyber Law Harmonization Framework, which was passed in 2011. Under that framework, all the partner states, except maybe a few, have passed cybercrime laws, they've passed electronic signature laws, they've passed electronic transaction laws, and under that framework, we were also required to pass data protection and privacy laws. Currently, Uganda was the first one to pass its law in 2019. Kenya followed immediately after. Rwanda also has an office that deals with it, and they've also amended their laws. And in 2022, also Tanzania passed its laws. So we know that the other partner states will follow suit, because when you deal with the issues as a region, even for that government that may be reluctant, you find that they are able to follow suit. Secondly, regional frameworks also help us in terms of harmonizing most of the clauses. Today we operate in a global village. You'll find that a number of our large companies that operate in Uganda, you find they also operate in Kenya and the rest of the region. So I think when we advance the regional discussion, we get things moving much better. Last month, I believe, we had our first knowledge exchange for data protection and privacy regulators. We had it in Kenya, and we had the privilege of having almost all the governments in the room, and were able to discuss some of our challenges. One of the outcomes from that knowledge sharing session was to make sure that we now invite even those countries that haven't yet passed their laws to be part of that, so that we encourage them, so that they make use of the learnings that we've taken. And we are now planning for the next knowledge sharing session, and it will take place in Uganda. And we are already going to invite the ministries of ICT, the people who actually make the decisions to pass these laws. The other way, now going back to the specifics of Uganda, obviously Uganda had already passed its laws. It's very important for us to also be cognizant of the peculiar circumstances of a given country. So you'll find that in some of the countries they have individual offices, let me say, that handle personal data protection. But Uganda is a bit unique because of financial challenges and the like. The office was set up within an existing office, but by law, its independence was provided for. That way you find that although our law was passed in 2019, and the regulations that operationalize the law were passed in 2021, we are actually already in existence, because the older institution is able to support on the common costs.
The kid.
Yes, to support the baby sister, let me say. And we found that has helped us to fast track the implementation. I know there are other countries that have followed suit, and they are benchmarking from us. I believe Zimbabwe is doing something similar. So we need to be cognizant of the peculiar circumstances of each different country. Now, when we go to government, it's also important for us as the technocrats to talk about these issues in a very simple way for them to understand. I was privileged to be part of the process for the development of the law and the passing of the law. One of the things that was very critical was to give examples that our legislators, our cabinet ministers can understand, because they are also human beings.
Yes.
And when it comes especially to the politicians, they are one of the largest groups that is affected by misuse of personal data. You find their health records in the tabloids.
Private life.
You find, you know, their entire private life is out there. So when you give relevant examples that show how these laws may improve their lives, how not having a personal data protection office may impact them, or a data protection law may impact them, then you find that they can easily actually support you in passing the law. I can say that for Uganda, we really had overwhelming support for the passing of this law.
Yeah.
Thank you.
Thank you very much for sharing that insight, and definitely something for us to note. These are really key points about the importance of harmonizing and regional efforts, and taking note of the various countries and the different stands where they are in terms of their political and economic situations. But this is a great point for us as privacy professionals to note, and also to encourage conferences like this to reach out to other jurisdictions that are not as, mature in their data protection laws, to join events like this to learn. To you, Dr. Clarice Girard, I have a question with regards to your experience. Are you online? Where you've had a lot of experience. How have these experiences, and how might they be relevant to Africa's data protection landscape?
Thank you so much for the kind invitation, first of all, and I really regret that I cannot be in person with you today. It's very cold here, and in Paris we have this big series of working party meetings at the OECD, including the Data Governance and Privacy Working Party meeting today and tomorrow. But if I could, I would be wearing a flowery dress and join you on this wonderful panel with these wonderful panelists, and I so much regret not being with you today. But thank you. I think I will actually, building on what I heard in the previous interventions and also on the previous panel, maybe if you will allow me, I will give an answer that will build both on this very peculiar, if you will, experience that I had myself in Asia, but also on my past experience at the French Data Protection Authority for many years. I joined the wonderful world of data protection and privacy in 2001, when it was considered a bit boring, frankly, and technical, and maybe not, such an important topic at the time. And look where we are today. It's a truly global conversation. And I think what is very important to say is that true, Patrick from the Council of Europe was saying earlier that it's still a very EU-centric conversation. It is very true that, because GDPR and so on and so forth. But really, this conversation is global, and regional developments are being watched with huge attention, with great attention, and particularly in Africa. And I mean, the world of data protection authorities is a complex one, a contrasted one. The work of data protection authorities is extremely difficult, even for the most advanced data protection authorities. Every day an uphill battle. You have to regulate the state that basically gives you your budget. You have to provide advice, usually ex post. You were not looped in early enough. You have to support industry, but at the same time, you hold a stick. It's an extremely difficult job. And therefore, this balance that you're discussing today with this wonderful woman, really, it's hard, but we have to stick together and use all possible channels of cooperations that exist. Well, there are, of course, Council of Europe that was mentioned earlier, Also the Global Privacy Assembly, which is the global forum of data protection regulators, where we see more and more African representatives, which is wonderful, and more Asian representatives too, which is wonderful as well. And Latin America is also beefing up its presence, and these are extremely positive developments. And I realize now, looking at the French flag under my name, that maybe I should be speaking French, and I apologize, I didn't really know. We had to juggle languages today. Now, to get to my particular experience in Asia, and that would be, of course, more of a personal comment because it's not related to my work at the OECD on a day-to-day basis since last year. Lots of similarities in the sense that Asia is a region, it's not a block, just like Africa is a continent, and it's not a block. We see, of course, regional initiatives like the Malabo Convention, the African Union is working, there are initiatives also in Asia Pacific, but at the end of the day, each and every country is alone and has its own challenges to face. And that is particularly difficult because the cultures are different, the legal history is different, the context, some countries are fully democratic, others, are moving in the direction of, you have to find a way that works for every single country while sticking to common principles and joining international and regional cooperation networks. And that is difficult, but it's working, and we have to hold strong because the conversation on privacy has never been as strong as today and as important. So we're really in this intermediate phase. It was very visible in Asia when I was there, and still today, of course. You have a mix of countries that start from basically nothing, right? No data protection law, no data protection regulator, and therefore no data protection ecosystem, if you will. And yet the demands, the expectations are there. Businesses process data, citizens see data collected on them, the privacy expectations, the privacy issues are real. And from one day to the next, the data protection regulator has to, be set up and start running as soon as it's set up, instead of taking, decades of development like in other countries. At the same time, in the very same region, you will see regulators much more mature who have been there, for a longer time, and have more or less stable budgets, more or less stable staff, are willing to engage into regional conversations, but their means are also limited they're available for international cooperation, but it's not always very easy to articulate that, and the distances are what they are, and so travel is expensive, and so meeting in person is sometimes difficult. Anyway, this is it was a really interesting experience to see just how the material, the logistics, if you will, of cooperation sometimes can create hurdles. But there were very positive lessons learned in a number of countries. And typically, Rudesha, you were saying privacy is a long-term investment. This is really the key message. Privacy is long-term investment. Let's make also privacy simple, as was just said. Let's speak the language of the people on the other side of the table to make sure that basically the authority, the moral authority, goes with the message. My experience was coming, of course, from Europe, where data protection is in fact a contraction of the protection of individuals with regard to the processing of their personal data, which is obviously a bit wrong. Where data protection is a fundamental human right. I had to adjust, and I was told, if you want to make an impact working with the governments in the region and talking to industry, don't talk about human rights too much, and it hurts when you hear that, at first. And then it's true. You have to adapt to the landscape, and that doesn't mean there is hostility to a human rights language per se. It's just it's not intelligible as such. And of course, when you go back to the roots of the development of even Convention 108 and the European Directive before GDPR and so on and so forth, yes, it takes root, in history in the 1970s and even before that in Europe. Now, we're talking to governments, we're talking to regulators, we're talking to industry and to younger generations who are basically digital native now for some of them. And the context is radically different. So it's about human centricity. It's about protecting individuals. It's about, and then at the end of the day, you bring in exactly the same content as a human rights discourse, but you bring it differently. It's good for business. What is good for business, even if it sounds a bit, well, businessy, right, for a regulator to say, if it's good for business, it's going to be good for everybody at the end of the day. But you have to make sure that it's a healthy long-term investment and to build the right conversations, in country with industry. And at the end of the day, the community, and I will finish here, but really what I saw in Asia in particular, particularly in Southeast Asia, is that at the end of the day, if you manage to build a strong community of data protection officers or data protection supporters, if you will, in the business industry, and the business community, there will be a very strong body of advocates for you, working together with, of course, civil society groups. They're instrumental because it's not all about business, it's protecting individuals in all their components. And that includes being a citizen, being a patient, being, an elector, as you were saying, a voter. And so we need to bring everybody together. It should not be the regulator alone. And really to finish on this, the role of international organizations, of course, speaking for the OECD, but all international organizations, whether they operate in the context of legally binding instrument or not, or informal networks, particularly networks of regulators, are absolutely fundamental, because this is how you gather information, you gather strength, you go back to your community as a regulator, and you take strength in the fact that your colleagues are doing good work, and you draw inspiration from it, and it helps also build your position. That was very visible in Asia towards the public stakeholders that you interact with on a day-to-day basis. I'll stop here. I'm sorry I don't see the room, so I can't see the interaction.
Thank you so much, Dr. Jura. That is very insightful, I must say. And I'm going to come back with another question about your experience in the OECD, because I think definitely we're here for knowledge share, and there's a lot we can learn from what's happening and the work you're doing at OECD. To cap what you said, is the importance of also integrating the masses, integrating the business lovers about the importance of the data. We can get advocates on the floor of other people who can start to demand for the governments to pay attention to this subject. So it is an approach from bottom up, from top to bottom, in such a way that everybody is asking for attention to be paid to a particular subject. I think with that, alongside with what Ms. Stella shared, we will get our governments to start to pay attention to this subject. Ms. Madop, in your role as a UN Emeritus expert and your involvement with the UN Global Pulse Data Advisory Group, what insights have you gained about the intersection of data protection, human rights, and global data sharing, and how can these insights benefit African countries?
Thank you for your question. I had a specific mission when I joined the Global Advisory Pulse Group at the time, which is no more now, but I'm still recognized as an emeritus expert, fortunately. In 2014, I went as a very strict militant of having a UN Global Convention on Data Protection. And we were the task force, who was tasked, actually, with designing that convention at the time. But definitely, we didn't get a convention, but we got some very good guidelines from the UN afterwards regarding data protection. And I'm still in the team which is militating for a UN Global Convention on Data Protection. And I hope that this at least before I leave my office, my tenure office, I will be able to see a very strong commitment from the UN regarding data protection and privacy. This is not to say that we don't have guidance, we don't have soft law approaches, you know, from the UN, but we definitely have to become like the Council of Europe, which has, you know, a binding, legally binding instrument at the international level. And this kind of strong message from the UN is required right now in extreme urgency, given that privacy has reached a level and breaches have reached a level which is beyond our, you know, our shoulders. And we're not being able to shoulder this responsibility, be it a regulator, be it a citizen, be it the international community and governments as well. And to alleviate or mitigate, you know, the criticality of the situation, we are obliged to act very, very, you know, very fast. And I think the UN is very aware of this situation and is having some problems, as you've seen with the Malabo Convention, with the Council of Europe Convention, all the time that it takes to ratify a convention. And by the time we ratify this convention, some elements contained in that document are already outdated. So that is a problem that we are all very conscious of, and I'm sure that the UN will come with the right efforts, but let us give it also some time. I think that's what I want to say.
Thank you. Thank you for sharing. Ms. Stella Alibati is still on the topic of collaboration among regulatory bodies, companies and government institutions for the crucial, effective data protection. Can you highlight? Let's talk about success. We've talked about the difficulty, but let's take a moment to say brag on the work of your office, because it would encourage us about the work that you're doing and to continue to work in that direction. So could you highlight some successful strategies that have been employed in Uganda by your office in the work and also collaboration with other government entities?
There's a lot of, as I indicated earlier, we are a fairly small office and very committed to ensuring compliance within Uganda. And one of the strategies we've deployed is collaboration. So we have collaborations with government bodies, we have collaborations with the private sector, we have collaborations with development partners, we have collaborations with the non-government organizations or the not-for-profit organizations or NGOs. So I'll give some of our success stories. With government, we are largely collaborating with regulators, because when you implement data protection and privacy laws, you do not implement them in a vacuum. In many cases, you're regulating people who already have a primary, what I will call a primary regulator. For instance, in Uganda, like I think many of our African countries, telecom companies do a lot of, they collect a lot of data, but they also provide services that sometimes may even go beyond what government provides. Because in Uganda, for instance, they provide the telecom service itself, but they also provide financial services. Because of mobile money, they are now going into even insurance, they are going into lending, they are providing a suite of services. And because of that, they interface with the large part of our populations. For instance, Uganda's population is about 40 million people, but you find that telecom providers have subscription in about maybe 15 or almost 20 million people. That is half the population. Yes. Now, for us to ensure fast adoption of our compliance requirements. We worked with the Uganda Communications Commission, which is the primary regulator for the telecoms. We also collaborate with the Bank of Uganda in terms of their fintech aspects and the like. So you find that, for instance, some of the things we've agreed on is it's important that the regulated parties see us as one government. So there is no need for the PDPO to go and audit. UCC goes and audits. Bank of Uganda, which is the central bank, also goes and audits. Some of the discussions we are having is that UCC can audit, put aspects of personal data as part of the audit, informed by the Personal Data Protection Office, and then proceed. So in a way that is helping us to have, a faster adoption. So you find, for instance, almost all our telecom providers are registered. They have their privacy policies. They've put in place complaints resolution mechanisms. You'll find that the central bank, almost all our banks, I think 100% of our banks are already registered. They have data protection officers. Even the central bank itself is registered. Within the central bank itself, the director audit is the data protection officer. So when you relate with other regulators, it makes your work much easier. And because industries also have peculiarities or unique circumstances, which you as the Personal Data Protection Office or as the regulator, you may not understand. But when you're working with their primary regulator, you find that you have a faster rollout of your initiatives. The other example I can provide is our collaboration with the NGO Bureau. In Uganda, all not-for-profit organizations are regulated by the NGO Bureau. And if you look at the number of registered entities on our register, the bulk of them are NGOs, because we have NGOs that operate across the country, and we are leveraging on that initiative to actually reach out to them. As a result of that engagement, we now have data controllers across the country, yet our offices are in Kampala for now. What has also been done is that the NGO Bureau does dialogues in the various regions of the country, in the north, in the east, in the west, wherever. So the NGO Bureau has now co-opted us. So when they have these dialogues, they bring together the NGOs, their representatives, they bring together local government leaders, and we are given that forum. So every time they meet, there's something to say. We send our personnel there to train, to resolve challenges, to support these organizations. So that is working very well. When we also talk about collaboration, we collaborate with the NGO world, and our biggest collaboration is actually with Unwanted Witness, which is the organization that has organized this privacy symposium. They started their symposiums in Uganda as we were drafting the law, and I would occasionally support them. Obviously, we interact in terms of providing training. When they want to provide training, like last year, they trained journalists. The previous year, they did training on within the health sector. So we provide that support. We also find that NGOs, for some reason, have money for awareness. Yet, us as government, that's the first budget they cut, when there's not enough resource. So you find that unwanted witness has amplified our voice, but also they check us in terms of where we are going, how we are progressing. You'll find that some of the investigations we've done have been as a result of the complaints that they've raised. So they act as a watchdog, yes, but they also help us to amplify our voice. Last year, they started the privacy moot competitions. This year, and we support them in terms of following last year. This year, we were more proactive. We provided training sessions for the students. We helped them with a marking guide or assessment guide. They did a boot camp, which we facilitated. And as a result of that, when our Court of Appeal judges, these were actual judges actually who are practicing, when our Court of Appeal judges interfaced with the moot competition, they found the candidates were better prepared, they were more coherent in terms of the arguments they made in court, and generally it benefits us. So collaboration is very key for us in terms of advancing our cause to ensure compliance with the Data Protection and Privacy Act.
Thank you very much. If I'm hearing rightly, I think this is encouraging for us. If you're a part of the law masterclass, we talked about if you are a privacy professional, that you should let your regulators know who you are. And we can hear today about the need for collaboration. It's not the regulators on one side and privacy professionals on the other side. We're all working towards the same goal, and the need for collaboration brings about really great result. I know that the audience has questions for our regulators, so in about 5 minutes, I have one question for Ms. Awa and the other question for Dr. Giroud. Ms. Awa, what successes can you just briefly highlight that your office has registered that you would like to share as an encouragement of what you've done?
What success?
Les succès de ton bureau, que tu voudrais en parler.
Oui. Peut-être ici, je voudrais juste parler de deux choses. La première, c'est au niveau national. En dehors de tous les partenariats que nous avons avec le secteur privé, avec les ONG, tout comme ma collègue Stella vient de le dire, qui est vraiment une coopération très forte, nous avons, avec l'administration publique, noté de réelles avancées. Je dois dire que quand je suis arrivée au sein de l'autorité, le grand problème, c'était l'adhésion de l'administration publique à toute cette conformité par rapport à la protection des données. Et tout le monde sait que l'administration est un grand collecteur de données personnelles. Et il fallait justement les pousser à réaliser et à prendre conscience qu'ils avaient des devoirs par rapport à ces traitements, ils avaient des obligations par rapport à ces traitements, et que ces obligations, c'était eux-mêmes qui les avaient signées, et que cette loi, c'était eux-mêmes qui les avaient acceptées en Conseil des ministres. Alors, ça, c'était un principal problème et un écueil paradoxal. Et je dois dire qu'au fil des années, aujourd'hui, je dois me réjouir du changement qui s'est opéré au sein de l'administration publique, je dis bien. Aujourd'hui, tous les grands projets dans le cadre du traitement des données personnelles qui sont mis en œuvre par l'administration publique, nous avons noté avec beaucoup de satisfaction qu'avant même de les enclencher, ils nous demandent un avis. Parce que dans la loi de 2008, notre première loi, l'avis de l'autorité n'était pas obligatoire pour le traitement de l'administration publique. Aujourd'hui, dans la seconde loi, dans la loi qui va bientôt voir le jour, cet avis est obligatoire. Mais déjà, dans ce laps de temps, de 2016 à aujourd'hui, nous avons vu maintenant une profusion de demandes d'avis qui émanent de l'administration publique. Et je dois dire que ça, c'est une reconnaissance et une reconnaissance du travail de la structure, mais c'est également une reconnaissance de cette obligation de mettre en place une culture de protection des données, une culture nationale de protection des données et du droit à la vie privée qui est en train de s'installer dans le pays. Et je dois dire que sur ce plan-là, c'est une satisfaction très grande pour l'autorité de protection. La deuxième satisfaction, c'est dans le cadre de la coopération internationale, c'est la coopération que nous avons avec Smart Africa et le travail que fait Smart Africa au niveau africain. Parce que je dois dire que si aujourd'hui la Convention de Malabo est presque en passe d'entrer en vigueur, si aujourd'hui la Convention de Malabo est en train d'être revisitée et d'être véritablement réadaptée au monde moderne et aux technologies d'aujourd'hui, c'est grâce au travail très proactif de l'Alliance Smart Africa, qui fait un excellent travail d'harmonisation des politiques en matière de protection des données personnelles, d'harmonisation des politiques en matière d'échange et de transfert des données au sein donc du continent, et qui fait un travail extraordinaire sous la houlette du président rwandais que nous devons quand même féliciter dans ce cadre-là, qui fait un excellent travail d'initiative et vraiment de mise en avant de ce qui est très important dans cet environnement d'e-commerce qu'ils sont en train de mettre en place, de donner une place à part à la protection des données, de donner une place à part à l'harmonisation des politiques en matière de protection des données au niveau africain. Voilà donc les deux choses qui me réjouissent particulièrement.
Thank you for sharing. Thank you very much. Dr. Girard, in about 3 minutes, if you can, please just tell us a bit about the work you're doing in the OECD, what you're working on, and how anything that can inspire our regulators as well as privacy professionals listening to you.
Je mentionne juste cela en français pour dire que j'ai pu parler en français sur ce panel pendant une toute petite seconde. And then I'll switch back to English then for our moderator. We do a lot of work, like everybody does a lot of work. And let me insist that the work we do, of course, is not limited to the OECD membership. And there is always a very keen interest in working with an extended network of partners outside the OECD membership. And I really look forward to coming to Africa sometime next year and again, meet with you all in person. What we do is basically we support the work of governments, primarily governments, in the context of a working party on data governance and privacy that basically supports the work of the so-called Committee on Digital Economy Policy, which is where all the governments of the OECD member countries gather to take a number of positions on digital economy policy. We have a very large number of members, and the profiles are very large as well. So we have representatives of data protection authorities, but we also have representatives of ministries with competence in digital. We have representatives of civil society, business, the technical community, the internet community, and trade unions and trade associations. It's a very large, very broad community. What we see is that the expectations are growing. I see that's a shared experience across the board on this panel. We see a growing number of challenges as well, but very positive developments where privacy is actually put at the heart of a number of key policy developments instead of being an afterthought. And the concept of privacy by design, privacy by default, privacy as a fundamental human right, privacy as an enabler, privacy first, that message is coming across more and more. So that's great. We do work on the implementation of the so-called privacy guidelines. The OECD privacy guidelines are a recommendation, basically, of the OECD, one of the first instruments, non-binding, unless unlike the Council of Europe Convention, but still very influential to develop data protection law since the 1980s. We do a lot of work to facilitate the implementation of the guidelines, which contain a number of privacy principles. Again, we do a lot of work to support the different networks. I'm sorry, my network connection seems to be a bit unstable. we do a lot of work to support cooperation and cross-border enforcement in particular. There is an important OECD recommendation in that space. And I would be very happy to actually involve, these wonderful panelists today in this work. As we're actually reviewing this recommendation, we've actually asked even Council to revise this recommendation to incorporate more recent developments among the considerations, among the developments that should lead to the revision. We also do a lot of work on privacy enhancing technologies, so-called PETs, and how privacy can actually, how technology can actually support privacy and not only, be a source of concern for privacy. It's very important to have this balanced approach. We do also a lot of work on data flows, reflections around the impact of data localization requirements, for instance, on business, without putting a value judgment on data localization, because that always is a difficult conversation to have with governments who really, find that, there are critical reasons to localize data onshore sometimes. It's a difficult conversation, but we need to have it. We have an important work stream on so-called government access to personal data held by private sector entities. The OECD countries adopted an important declaration last year, adopting a number of common principles to that countries basically abide by to foster trust in the development of the digital economy and support cross-border data flows, so that we have some assurance that governments in democratic countries actually abide by a number of principles when they access data held by private sector entities for law enforcement and national security purposes. It was a difficult work, but it was successful. We're looking at the next steps. And I will close here. There are many more things I could say, but we also do a lot of work, and that will certainly resonate for Rhodesia and others, on the intersection of data protection laws with sectoral regulations, and in particular in banking, finance, health, AI, protection of children. We see that there's a number in these very heavily regulated environments. It's actually becoming harder and harder to accommodate the growing number of requirements that apply out there to one single company, one single organization. It actually also is the case for some government entities sometimes, and that is a problem because it raises costs, of course. So it's the negative vision on data protection. Data protection is about costs, it's about constraints, it's about difficulties, and so we need to assuage that concern. It's also an impediment to cross-border cooperation, and that's not a good thing. So we're working a lot on that. I'm conscious of time. I'm very happy to provide more comments in writing later if you want, or to participate in another event another time. And this time I swear I'll be there in person. And thank you again for the invitation.
Thank you, Dr. Giroud. Sincere apologies to the audience. We will not be able to have Q&A because we have just 5 minutes before we take our lunch break. But this has been a wonderful session. I hope you have been able to gather some information, some insight, some encouragement as we have had this conversation with our regulators. If anything I have taken out of this is the need for collaboration and the need for each and every one of us to add our voices to make sure that our governments are also as interested as we are in the protection of our data privacy. Thank you all so much, and please, with a round of applause, say thank you to our regulators.
Another round of applause. Without wasting any time, shall we proceed for lunch? Kindly, let's be back here by 1:50. Thank you so much. You've been a wonderful audience, and I look forward to having you back. Thank you.